Chair, I think this is the only day where Senator Welch shouldn't have to apologize. It's his birthday. Happy birthday.
Thank you.
Thank you all for being here. I actually came with some prepared comments to talk about what I thought was covered very well by Senator Graham and Senator Kennedy. So I'm not going to talk about the current state of affairs, but I think that our behaviors and the behaviors of some people in this country have created a really toxic and very dangerous environment for the Supreme Court and the judiciary down the line. And that's what we need to be aware of. We have to stop this here because it won't end here. We'll have protests at district judges' houses. We will have circuit court judges stalked. I mean, we've got a serious challenge here, and I think it's in large part on Congress to de-escalate the situation. But Mr. Dupree and Professor Frost, in you all's opening statements, you looked like you were preparing your opening remarks for a debate on the constitutionality of what we're considering here. And so I'm going to create an ad hoc debate between the two of you and maybe allow others, if you want to raise your hand and opine. But you laid out in 5 or 6 minutes a very strong case for saying that any actions we would take here could arguably be unconstitutional. I do think, stipulating to what Professor Frost said in her opening comments, there is clearly a role for Congress to play, and we have in the past with creating the structure for the Article III branch that was mandated under the Constitution. But I'm kind of curious about Professor Frost's idea of where the line goes, because I could have read your comments to say that all of the proposals that are before us in the Senate and the House would pass constitutional muster. I think the one that I found most interesting that I'd like your opinion on is the proposal, I don't recall the bill number, that really created the structure where circuit and district courts were really going to be empowered to govern the proceedings of the Supreme Court. Maybe if you're aware of this particular bill, we can go right to your rebuttal, but that seems to be far afield from anything that the founding fathers would have conceived congressional action being appropriate. Would you elaborate that on that for 30 seconds?
Absolutely, Senator, and thank you for the question. The first point is yes. I mean, I think it just is self-evident that you can't constitutionally have a system in which the Congress vests inferior tribunals in our federal judiciary with supervisory authority over the United States Supreme Court. As you know, and as this committee knows, the opening of Article III of our Constitution vests the judicial power in one Supreme Court and such lower courts as the Congress may from time to time ordain and establish. And so I think the framers necessarily understood that we have a pyramid. We have one court at the top, we have inferior tribunals below it, and it stands to reason that you cannot vest those inferior tribunals with supervisory authority, including the power to disqualify from a case the Supreme Court justices.
Okay, Professor Frost.
Yes, so if the legislation you're referring to says that the judges on the lower courts will be reviewing the ethical conduct of the justices, that is maybe their financial reporting and not their recusal decisions, I don't see a constitutional problem. The same way there's not a constitutional problem with a justice being prosecuted if they commit a crime like any other judge. So no, the lower courts couldn't review the Supreme Court's decisions for the reasons that Mr. Dupree just gave, but they certainly could review their ethical conduct off the bench as a constitutional
What do you think about the, we're the political body. We were envisioned to be that, and right now they seem to be all doing very well. But it would just seem to me that you'd be creating a framework to where the outside could game it and divide the courts. I mean, suddenly you'd have a group of district court judges who would have one agenda that they would be advancing. You would have others another agenda, and probably some of them not unlike what we have here on any policy matter. But it just seems ripe for really seeding the field with the politicization of the court. Starts with ethics, but where does it go from there?
Well, I think that's a very serious concern, Senator. I would say in two respects. One is that there's a serious concern that litigants could try to game the system to determine the justices who would be hearing their case. In other words, some of the proposals before the Congress right now would allow third parties to challenge the ability of a justice to participate in a decision. And if that provision were to become law, I promise you, as someone who litigates regularly in the United States Supreme Court, round one of any litigation would be trying to knock out the justices who you think might be opposed to you. That's untenable. Number two, the problem is if if you create a system where individuals are incentivized and encouraged to file ethical complaints, I worry that long-term that ultimately
It'll be a
will
cottage
corrode
industry. We already have it in other branches of government. It will be a cottage industry. It will be politicized. We will diminish, I think, the integrity of the Article 3 branch as a result. For my part, I think the exchange of information here may be helpful. What I think is more important is that I think that the Supreme Court and clerks are watching this right now. We have heard examples of instances of behavior at either end of the ideological spectrum that was unacceptable behavior. I, for one, hope that this does nothing more than turn into an oversight hearing, not something that lays the groundwork for congressional action, and that the Supreme Court, who rightfully declined with the concurrence of all justices not to come before the committee, that would be a political circus and almost unprecedented in terms of American history to have a hearing of that nature with the Chief Justice. So I just hope, what I care about most is not your confidence in the judicial system, not necessarily the confidence of any one member here, but a confidence of the American people. And I do hope that this process has been instructive to an Article 3 branch who should independently, in the same way that I have an office code of conduct that all my staff have to read and affirm every year. I don't know how many Senate offices have that, probably not many. But I think that they could update, refresh, and address the concerns without requiring any congressional action. And if they act in the near term, maybe this committee could be instructive. Thank you for your time.